like it.
All right. Good morning, everyone. We are pivoting a little bit this morning. We're into pivoting here. You will see on our committee's webpage, H657. So we're gonna have a walkthrough of H657, which is, you have heard me refer to an omnibus DCF bill. So we had a little committee comprised of Ray and Jubilee, Esme, Ann, and I, right? So, yeah, okay. And is anybody? Esme wasn't there, right? No, just Jubilee. Okay. That took a look at all of the things. Sorry, my brain's a little scattered this morning. I've done 3 topics before 9 o'clock. So rewind a little bit. At the end of last year, we were taking a look at the bills on our wall. And we noted that there were several having to do with DCF and the Family Services Division. And rather than try to not do any of them justice, and since they had some interlocking pieces that sort of built on each other, I had said that we would look at, and Jubilee and Ann sort of thought about this over the summer about how we might approach doing an omnibus bill that sort of, brought together all of these distinct pieces. And so we've been working on that, and Katie's been working on that, and other attorneys have been working on it because it crosses over jurisdictions in some areas. Dan's had a little piece of it. So there's been different things happening with it. So this is one of those things that is complicated and simple at the same time. The concepts are simple. The law is complicated. Katie, could you join us?
Sure.
Yes.
Is there money attached to this?
There is not money
No
attached
money
at this point.
Great.
Morning.
Good morning.
Katie McGlynn, Office of Legislative Counsel. So there was a little switcheroo this morning.
Yes.
I haven't perhaps through this bill. When I'm in Senate Health and Welfare and Senator Lyons asked me to do something complicated, she always says, "This is going to be fun." So
Okay.
it might be fun.
Does that make it any easier on you?
Just with Senator Lyons, so I'll repeat it. This is going to be fun, Katie.
So it might be a little bit like that, a little bit bumpy, but we'll go for it.
Thank you for putting up with the change.
No problem.
Just felt because this is a pretty complicated bill that I needed people to start to get their heads around it if we're going to pass it out by crossover. So.
Okay, so we're looking at the bill, H657. Several different attorneys working in this, and I'll sort of alert you to who the point person is on a particular section when we get there. Let's just go for it. So the first section has to do with reach up, and this removes the asset limit in reach up. So right now, there's an asset limit of $9,000, and then we have language about exceptions when an asset limit shouldn't be considered for the purpose of calculating the asset limit. So this whole subdivision 5 would be eliminated. So right now we have language that says the commissioner shall adopt rules for the determination of eligibility for the REACH Up program and benefit levels for all participating families that include the following provisions. And then this provision would be removed from the rule, but the asset limit shall be $9,000 for families for the purpose of determining initial and continuing eligibility for the REACH Up program. And the following savings account shall not be considered in the calculation for determining asset limit. And that's a retirement account such as an IRA, defined contribution plan, or similar account. And at the top of page 5, a qualified child education savings account such as the VHIP, Vermont Higher Education Investment. That is the first topic. And then, oops,
Are you okay for us to ask questions?
I can give it a go, yeah.
Okay. So I'm wondering if I understand the first part, the asset limit, but then if we remove the parts that say shall not be considered in the calculation,
Mhm. Well,
because there's no
wouldn't
limit,
be
it's
calculation
limit.
at all.
Yes, it
Yeah.
wouldn't be any calculation at all. Thank you.
Yeah.
Thank you. Sorry, I just connected with I was thinking about benefit, not,
Yeah, I did the
Calculation
same
asset.
thing when I was
yes.
thinking it through. Well, okay.
Okay.
So then we're changing from reach up to a new topic, and that is youth and foster care. And so, yeah,
Sorry, what's with section D there then, right above,
that's existing law,
and it remains?
and that remains. Yeah.
Okay, so
So it's showing the whole so what it would look like in the green books if this were to pass is you'd have a 5A that would say repealed, and then you'd still have a 5B.
let's see, okay.
That's
So
why
when
it's
you said
shown.
the entire section, you meant 5A.
Yes,
I
the
see,
whole
okay.
subdivision
I thought you meant
5A.
5.
No, 5B would be retained.
All right, thank you.
Yes, thank you. Okay, changing to social security benefits for youth and foster care. The point person in Ledge Council for this is John Gray. So first, you have a definition section. These are all existing definitions. And there is the addition of several new definitions at the top of page 3. So qualified able account means an able account, as that term is defined elsewhere in statute, or an account established pursuant to any qualified state able program created in federal statute.
That's something we already have in Vermont. We're just adding it to this statute.
In subdivision 6, representative payee means the person appointed by the Social Security Administration to manage the Social Security benefits of a child.
And just for people who might not be accustomed to this, person in legislative language doesn't have to mean a human being.
Mhm.
Right? Correct. So in the case.
Could be an entity or
it could be-
corporation.
yeah,
Yeah.
Corporation could be a department in state government. Could be-
RSDI benefits means a child's retirement, survivors, or disability insurance. There's a definition of the Social Security Act, which cites federal law. Social Security benefits means a child's RSDI benefits or Social Security income benefits, or both as applicable. Supplemental security income. And then 10 is SSI benefits, supplementary security income, and it cites to federal law. And then we have the corresponding section that these definitions modify. And this says that a department is not to use any portion of a child's Social Security benefits to offset the state's costs for the child's maintenance, except maintain the child's eligibility for SSI benefits and to avoid a violation of federal asset and resource limits. So you can only use the benefits to the extent it helps maintain SSI. Then in subsection P, in its capacity as representative payee for a child, the department may use the child's Social Security benefits for the child's unmet needs beyond the amount that the state is obligated, required, or agrees to pay after notifying the child's parent, legal guardian, or counsel, the family division of the Superior Court, and the Office of the Child, Youth, and Family Advocate. In its capacity as representative payee for a child, and with the assistance of the state treasurer and the department shall establish a trust account for the child, which shall be a qualified able account for any child receiving SSI benefits. It shall monitor any federal asset or resource limit for the child's SSI benefits and ensure that the child's best interests are served by using the child's Social Security benefits for the child's unmet needs or conserving the child's social security benefits in a way that avoids violating any federal asset or resource limits that would affect the child's ability to receive SSI benefits. And the department shall provide an annual accounting of the use, application, or conservation of the child's SSI or social security benefits to the child's parent, legal guardian, or counsel, family division of the Superior Court, or the Office of the Child, Youth, and Family Advocate.
Katie, do we know, or Dan, you might know this, do we know if that's something that number 4 is something that's required already? I think Representative Page is supposed to do like
Yeah.
a annual filing or something.
Yeah, but I think that just including those other individuals just to keep track of it. But I think they do have to keep track of the amount.
Of the amount, yeah,
Mhm.
okay.
I'll ask. I'll just flag it. Okay,
That was topic number 2,
big number 2.
and we're going to topic number 3.
So at the top of page 3, we have enabling unaccompanied homeless youth to obtain certain services without parental consent. This has a number of sections with kind of falling within this topic. But because they kind of jump all over the green books, we have some relating to motor vehicles and we have different titles. So I've tried to put little headings in that start off with unaccompanied homeless youth. So like before vital records or getting a driver's permit. So you can sort of know that they're all relating back to this section. So first we have a definition of what an unaccompanied homeless youth is. It means an individual who is 16 years of age or older and who is not in the physical custody of a parent or guardian, including a youth who has run away from home, who has been forced to leave home, or whose parents have left the area and left the youth behind. And then there is language about obtaining a certification that the individual is an unaccompanied homeless youth. So an unaccompanied homeless youth may become certified if the youth is found by a school district's liaison for homeless children and youths or other appropriate staff person to be an unaccompanied homeless youth eligible for services pursuant to the federal McKinney-Vento Homeless Assistance Act. If the youth is believed to qualify as an unaccompanied homeless youth, as that term is defined by the federal McKinney-Vento Homelessness Assistance Act, by the director of an emergency shelter program funded through HOP or designee, the director of a runaway or homeless youth program funded by the U.S. HUD, or the U.S. Department of Health and Human Services or designee, or by a continuum of care lead agency or designee. So both of those things have to be true.
I would probably remove a reference to HOP.
Okay.
You can say funded by the state of Vermont.
Yeah.
What page is that?
Page 5.
It's at the bottom of page.
There you go. Funded by. Proof of certification. The department's Division of Family Services shall develop a standardized form that shall be used by entities specified in the subdivision below to certify qualifying unaccompanied homeless youths. The front of the form is to include the circumstances that qualify the youth and the date that the youth was certified, the name, title, and signature of the certifying individual. And the section shall be reproduced in its entirety on the back of the form. So that if anyone has a question about what this form means, the statute would appear on the back. A certified unaccompanied homeless youth may use the completed form to apply at no charge and without parental consent for a non-driver identification card, a learner's permit or an operator's license or operator's privilege card. They could apply to obtain a vital event certificate without parental consent and at no charge. Top of page 7, they could use the certification to consent to care by healthcare professionals licensed or certified in Vermont, including medical care, dental care, mental health services, including psychological counseling and treatment, psychiatric care and substance use prevention and treatment services, and surgical diagnosis and treatment, including medical diagnosis and treatment such as preventative care and care provided in a healthcare facility for either themselves or for the youth's child if the certified accompanied homeless youth is unmarried, is the parent of the child, and has actual custody of the child. The certificate would allow the youth to enter into an agreement for housing or obtain admission to a shelter, would enable them to obtain employment pursuant to any limitations in Title 21. It would allow them to purchase an automobile and obtain an automobile liability policy. It would allow them to obtain a student loan, obtain admission to a high school or post-secondary school. It would allow them to open an account in a state or federally chartered bank or credit union. And it would allow them to receive services for victims of domestic or sexual violence as appropriate.
Before we move on, can I, I'm trying to understand back on, little I, 2I. Allowing them to receive medical treatment for
Mhm.
themselves or their child
Mhm.
if the certified unaccompanied homeless youth is unmarried. I don't understand why that's there.
I can't remember off the top of.
I'm just trying to figure out, does it mean that
I think they can if they are married.
if they're married?
I guess it's that maybe then consent by two parents would be required. So they're simply saying, it's intended to say that if unmarried,
I don't think
Thank
consent
you.
is required by two parents.
No, it's not.
Okay, so we just need a little more information about that.
Okay, I will look into that.
Okay.
Okay, so
I
I'm
was reading it makes it sound like if the youth is married, then they don't have the right to they don't have the right to seek treatment for their child, which I didn't understand why they would be giving that up.
yeah, I hear the concern. I'll have
Okay.
to look into it. I don't remember.
Okay, all right, great, thank you.
Vaguely remember it being something to do with they already have a lot of these rights if they are married or something. The way our statute is, but no, it's been a while.
It could be that we could just be silent on it.
Yeah.
They're the parent of the child and have actual custody of the child.
Thanks, yeah, go ahead.
Just quickly, does allowing minors to take on liabilities expose the state or provide us any legal risks?
Well, a lot of that would be, I think we'd have to go through each of these items one by one to sort of think through what that would be. The fact that the state is authorizing this, takes off a little bit of the liability. That they're not, for example, a healthcare provider. Ordinarily, unless it's allowed by statute, wouldn't be able to provide certain services to a minor. But if it's allowed by but if it is allowed by statute, we have some services where we, by statute, already authorize a minor to consent to certain healthcare services. So I think having the statutory language allowing certain activities provides some shield for liability. But again, I think it's worth going through each of those items one by one to fix.
I'm looking at it more from the liability in regards to like, for instance, it's written on up there that a minor could go and get a car loan.
Hmm.
And if they don't pay the car loan, could the state be liable for payment of that car loan?
I hear.
That's what I'm talking about in regards to legal risks.
I think it's a good question. I think that it actually places the liability on the individual. And so then you have a youth potentially taking on debt that they maybe can't afford. And so, I think it's a valid point to consider.
Yeah, but it's the reverse. It's the
So
The
youth is taking on
liability,
the risk.
right, the liability protection is for the one giving the service, not for the one receiving it.
But I think it's a,
I think that needs to get clarified in some cases.
yeah. And I also think that we need to think long and hard about whether enabling, there's certain things in here that seem like obvious to me. If they want to be able to work and, they want to be able to, have admission and, get a non-driver's ID and things like that. Taking on debt when you might not have the capacity to take on debt, or really maybe even to understand that you're taking on debt, might be a different thing. So, yeah, it's a good question.
I would note that this child's same parents could go and take out a loan in their name. So if we're going to say things like that, then we should make it so that, 16-year-olds can't have a loan taken out in their name, across the board.
So parents can take it out in the child's name.
Oh, yeah, it happens all the time.
I
Yeah.
don't know. I don't
Yeah,
understand.
it's the coercive debt bill. It's, we see it a lot in youth populations. They turn 18 and find out that they now have thousands of dollars of debt that they had no idea about.
They just know about.
Yeah.
Okay, thank you.
Well, I think just to follow up quickly, is anything under Vermont law that currently is in statute that limits minors from going into any type of contracts?
I would have to look.
I wonder, practically speaking, how much debt could they take out without? The marketplace would dictate how much
They
someone
would say
may,
no, right.
would say no. We would hope,
Hope though.
unless you would hope. Yeah.
Funding.
Yeah.
That would.
But if, in most instances,
That's kind of what I'm getting at.
Yeah,
But then that would be.
then did if they have the assets to say yes, would there also be a problem?
Well, if they're protected from liability, they might be more than willing to make the loan, but that might be gross negligence.
thanks, Katie.
Yeah. Subsection D, it governs the use of the form that a healthcare professional may accept the completed form as proof of the youth's status as a certified unaccompanied homeless youth and may keep a copy of the form or card in the youth's medical file. Then consent of a parent or guardian. And
Is there any reason why we would limit that to the health professionals' ability to?
I think you could probably expand it to other, if the school would like to have a copy of the form, or, if a lender was basing their decision on this statute, keeping a copy of their form on record. I'm not sure, but yeah, potentially. Okay. Subsection E, excuse me. An unaccompanied homeless youth's parent or guardian shall consent to the youth living independently or obtaining benefits or service pursuant to subsection C, but consent can be implied by the act of forcing the youth out of the home, refusing to provide financial support to the youth, or abuse and neglect. So those conditions would constitute consent for the unaccompanied homeless youth to act independently.
Curious about just reading this for the first time, but the shall language, an unaccompanied homeless youth's parents, guardian shall consent to the youth living independently
Mhm.
or obtaining benefit.
So
So
this,
any 16-year-old who states intention, the parent must acquiesce to that?
This is,
I think this is
No, I'm
saying
just trying to
that
figure it out.
that a parent, the consent of a parent or guardian is still required for the person to be obtaining these services by themselves, but things that you wouldn't ordinarily think of as consent, actions of consent, or would count as consent in this case, like abuse and neglect would be constituted as consent to do things independently.
Find their consent for them to do all of those other things.
I think it might be a wording.
Nature of the youth being out of the home.
I get that part of the language and I like that, but just the first clause in that sentence is.
Yeah, we could
A parent
reword
or
that.
guardian shall consent to youth living independently or obtaining a certificate pursuant.
Yeah, I think it could be a wording issue where we could
Wording,
have
yeah,
that.
yeah.
Go ahead. Go
Could
ahead.
I follow up this quickly in regard? Is the, sorry, let me just get my thought. Is the implied consent standard legally sufficient without a judicial ruling?
I'm trying to remember, it's been a while since I worked on this bill, but there were others, I think this was based on other state statutes from other states. And that's where I pulled it from.
I'm gonna
So-
send you the list of states. There's like 30 that use this around medical. And 18 around, I think, or so around shelter and housing and other services. And then there's some that, and a lot of those are the same states. It's designed, it works for federal, even like federal standards. There's programs that exist that provide shelter and services. We have them here in Vermont for youth under 18. The requirement is they have parental consent. And this implied consent, this is why a lot of states developed it, is it allows them, it meets the federal kind of bar for providing it and without any kind of judicial process.
Well, the only reason I'm bringing up some of these questions that I'm bringing on up is I'm not as informed and. And I'm just seeing a lot of liability that could be potentially placed upon the state to take care of fallen obligations, or are we doing things that need to be ordered by a judge? That's why I'm questioning.
Right. I don't see the state liability like you're seeing potentially the state liability. But I think that the notion about what can satisfy for certain programs and access to certain services, I think is certainly we can have Judge Zonay weigh in on his thoughts about it.
Mhm.
And I'm certain that he probably is familiar or will make himself familiar with what the other states are doing. So we'll add Judge Zonay to the
And
witness.
Julie, if you could send me that over.
Yeah, so I'm gonna send it out to everybody.
Thank you, Julie. Go ahead.
There are two items that we asked judiciary to do a flyover on, and this is one of them.
Yeah.
I think the whole intent is there is a judicial process for being emancipated, which like covers everything under the sun. You're an adult. And the idea is that's a burdensome process. And there are certain things that if a kid is homeless, we want to exempt from that process for these purposes. So that it's sort of an intent to not have to go through a court process for these specific things. And other things beyond that, you have to do the whole court emancipation.
Yeah, no, in regards to like some of the other things in regards to certification, what happens if it comes to fruition that the certification may have been invalid? Is there any type of guardrails in there in regards to those certifications that were then recognized as like, oh, it was invalid or we miscertified, or is there a recertification process?
Like if there was false information provided or, something like that.
Something like the provider was acting on good faith, that the certificate was valid, that they can't be held.
Yeah.
Something. Okay.
Yeah.
I'll keep thinking that through.
Yeah.
Continuing on, consent can also be demonstrated by a letter from a homeless service provider or school district, homeless liaison, or other appropriate staff member for any service or benefit authorized under subsection C of this section. If a parent or guardian's consent is required to obtain the service or benefit, the division shall stand in loco parentis and provide the necessary consent in place of the unaccompanied homeless youth's parent or guardian. So it allows the youth to do this And if it is something by statute that requires a parent to obtain, then the department would act as the parent. For the purposes of implementing C2A, to remind myself what C2A was, or C21. Let's see.
C2I. Open an account. 19 on page 7.
C2I.
Opening the bank account or credit.
Okay, glad you can find it. Oh, right here, C2I, okay. So specific to C2I, opening the bank account, the division shall consult with the Commissioner of Financial Regulation to ensure that minimum youth certification requirements are met for the purpose of making it legally permissible for a bank, credit union, or insurance company to contract with an unaccompanied homeless youth without the assistance of a parent or guardian, and with the understanding that the unaccompanied homeless youth may not have a permanent physical address.
I don't,
Go ahead, if you have a question.
a bank can't do that, can they? I used to work at a bank.
This is saying is that it can.
This is
How would they? Okay, that's okay.
creating a pathway by which the bank could have that relationship with a client who's an unaccompanied homeless youth.
But, okay.
Oh, and then we have
the federal. Okay,
We have immunity from liability language. Any entity, provider, healthcare professional who contracts the unaccompanied homeless youth pursuant to this section shall be immune from liability for the determination to contract with the minor unless the entity, provider, or healthcare professional acted with gross negligence. So then that kind of gives us the framework of what we're going to be looking at. And then we look at several sections that are conforming sections with what has just been permitted in the section 4 that we just reviewed. So first we have language about vital event certificates. In subsection B, the register shall waive the fee for certified copies of vital event certificates issued to an unaccompanied homeless youth who has obtained a certification pursuant to section 4908. Non-driver identification cards. This adds to the list an unaccompanied homeless youth who has obtained a certificate. What was the lead-in language? This talks about the department standing in loco parentis. The commissioner shall require a $29 fee at the time of the application for the identification card, except that an initial non-driver identification card shall be issued at no charge too. And that C is adding unaccompanied homeless youth to the list. Next is the license and privilege cards. Rolling down. An unaccompanied homeless youth who has obtained a certification pursuant to 4908 shall be provided with an operator's license or operator privilege cards at no charge. No additional fee shall be due for a motorcycle endorsement or an unaccompanied homeless youth who has obtained a certification pursuant to 4908.
so who would pay these fees? Because like the copy of their birth certificate is local, that would come out of like Milton, their taxpayers. So who would pay these fees?
So that there are already provisions in statute for certain people under certain circumstances to not pay fees. So that already exists in statute. And what we're saying is for a youth who's I don't like using these terms, but who lacks the active assistance of family members because the family members are no longer in their lives.
Who's on their own.
They're on their own. So we're just saying youth who are on your own, you've already got enough problems. If you need to get access to a learner's permit or a license of some sort, we're not going to charge you a fee for that.
But who pays it? Like, I wouldn't want it coming out of the taxpayers of Milton if somebody came and wanted a copy of a birth certificate. So who would pay it?
I don't know, that would probably
Who
cost
pick
about
up the
3
money for the
cents.
Milton taxpayers?
It's not the Milton clerk, it's the state
State.
agency of transportation. So Tax base is different.
I see a lot of money involved here. Okay. That for struggling
There's not
people
that-
already.
There's not that many unaccompanied youth. I mean, there's enough of them, more than we'd like to think, but
More than doubled in the past 5 years.
But this goes to 24 years old as an adult. Okay, that's okay. Let's not argue. It's, doesn't make common sense to me. Okay, thank you.
okay.
I think there is a full picture consideration here as well, though, to talk about like employment, like if you don't have proper identification, it is really hard to get a job. So like, it's not just, it's a ripple effect on several other aspects of our economy too. So for very, very small input.
We want to keep them off reach up, which would cost the state a whole lot more money than the tiny amount for getting its driver's permit and thereby being able to get a job.
What would that? Okay.
Okay, let's keep going.
Okay, next section is learner's permit. The commissioner shall require payment of a fee of $24 by the time the application is made, except that no fee shall be charged for an unaccompanied homeless youth who has obtained a certificate, and then the existing law, or for an individual under 23 years of age who is in the care and custody of the Commissioner for Children and Families in Vermont after attaining 14 years of age. In subdivision 2, we have similar language that the fee for the examination shall be $11, except that no fee shall be charged for an unaccompanied homeless youth who has obtained a certification under section 4908, or an individual under 23 years of age who was in the custody and commissioner of DCF in Vermont after attaining 14 years of age.
That's existing law. That's part of the
Existing law. Subdivision 3 is the motorcycle learner's permit.
So another concern, if they don't have any money, how would they have a motorcycle to get a permit? I guess this is really concerning.
They may or they may not.
Okay.
This is, Brenda?
Yeah.
What this is doing is trying to make all of the language that exists in certain fee areas consistent. It doesn't mean that they're going to have a motorcycle. It's trying to make everything consistent so that it appears in all sections of applicable law. Thank you. Okay.
Okay. So we have a similar language in subdivision 3. An unaccompanied homeless youth who has obtained a certificate pursuant to section 4908. And then existing law, somebody 23 years of age is in the care and custody of the commissioner for DCF in Vermont after attaining 14 years of age shall not be charged a fee for the renewal of a motorcycle learner's permit. Subdivision D, the application, the existing law, the applicant is to pay $24 for the commissioner of each learner's, to the commissioner for each learner's permit or duplicate of renewal thereof. And then in subdivision 2, an unaccompanied homeless youth who has obtained the certificate shall not be charged the fee for the learner's permit or duplicate or renewal thereof. So that's the last of those conforming sections that go with the sort of, they were part of the original bill on unaccompanied homeless youth. So we're changing to a new topic if that is okay with the committee.
Yeah.
Okay. So next we have a section on the mechanical restraints and transportation of children. We're first amending existing language. Existing law that the Commissioner for Children and Families shall ensure that all reasonable and appropriate measures consistent with public safety are made to transport or escort a child subject to this chapter in a manner that prevents instead of reasonably avoids physical and psychological trauma. That change tracks with a similar language change in Title 18.
Yeah, sorry.
That's okay.
I just was like, reasonably avoids. I'm like,
Insufficient.
insufficient, right?
Well, I might as well jump in this and the next piece. When this statute was first passed, the language was identical for children in the custody of DCF and people with a mental illness in the custody of DMH, not using shackles and so forth. Over time, there were changes made to the DCF one, and there were changes made for the DMH one, but they weren't pulled together into one, and that's what this is doing.
So it's really updating it for children
they
that the
match,
other
yeah.
ones, so they match, yeah.
So I will skip ahead to I think it's maybe important to just go over the existing law. So subsection B, the commissioner for DCF shall have the authority to select the person or persons who may transport a child under the commissioner's care and custody. And C, also existing law, the commissioner shall ensure supervisory review of every decision to transport a child using mechanical restraints when transportation with restraints for a particular child is approved. The reasons for the approval shall be documented in writing. This section in particular is cross-referenced later, which is why I wanted to slow down and look at it.
Yeah, I wonder if they actually do that.
Yeah.
They do.
They do have that policy.
Yeah.
It's been in law for,
I know it's
like
been a
20
long,
years.
it's
Yeah.
a supervisory review, I'm just,
Well, right, the degree of it.
since they couldn't tell us how many people
Yeah,
forever.
You'll see that later in this
Okay.
section. Reference.
All right.
So in D, we have existing language. That's the policy of Vermont, that mechanical restraints are not routinely used on children subject to this chapter unless circumstances dictate that such methods are necessary. The new language is that a law enforcement vehicle or private agency under contract with the department shall have soft restraints available for use as a first option, and mechanical restraints shall not be used as a substitute for soft restraints if the soft restraints are otherwise deemed adequate for safety. In subsection E, annually on or before January 15th, DCF is to submit a written report to the various policy committees addressing the number of secure transports of children during the previous year, including the age, gender, and racial background of the children transported. Top of page 16, whether the transport was conducted by law enforcement or a private agency, the number of children transported using mechanical restraints, when applicable, the type of mechanical restraint, the type of custody children were in when transport occurred, and the purpose of the transport. Then we have some definitions. Mechanical restraint means a type of restraint using a mechanical device, material, or equipment that restricts freedom of movement or immobilizes or reduces the ability of a child to move the child's arms, legs, body, or head freely. Physical restraint means a type of restraint using a manual or physical hold that restricts freedom of movement or immobilizes or reduces the ability of the child to move the child's arms, legs, body, or head freely. A physical restraint shall not include a light touch to encourage a response or to provide direction or guidance, provided the child is able to move away freely. And restraint generally means any manual hold, physical restraint, or mechanical restraint that restricts freedom of movement and immobilizes or reduces the ability of the child to move the child's arms, legs, body, or head freely. Secure transport means any transport in which restraint is used or in which a child is restricted from leaving a vehicle by means other than a standard car seat, seatbelt, or car locks.
And I'll just note that I did a little more background on what language other states use and so forth, and I haven't updated draft definition for that.
Okay.
That clarifies it.
I have a question, not so much on what we've just been, but I'm just wondering about chemical restraint. And it's not identified, and I would hope that it's not being used, but I think we should be clear that it's like all of these things.
Yeah, no, I think that's a good point, because despite how we define restraint, under CMS, restraint, the definition of restraint includes chemical restraint. So
Yeah.
if we're saying restraint and we're only saying, you can't do mechanical restraint,
Right.
That's a good point.
Yeah. So we need a definition for chemical and include chemical.
I have one lower down in the bill, I think.
Oh, in the bill later.
We use it.
For chemical,
Do we not?
maybe it may be in the restraint seclusion in residential.
In
homes.
residential.
It may be there, and so you hold the same one.
So we'll just need
Yeah.
to insert chemical restraint paragraph in here.
It's 23.
Very good.
Okay, so I can make those changes. Then we have a report on mechanical restraint and transportation of children. By September 1st of this year, DCF shall submit a written report to the policy committees addressing how the department is effectuating the policies set forth in 5123D. That's the language that we were looking at previously. It's this language. So it's the policy of the state of Vermont. The mechanical restraints are not routinely used on children subject to this chapter.
So, I mean, do we want that to be only mechanical restraints that are reported on?
Oh, the title?
Yeah,
No, because it's supposed to be the whole policy, which is least restrictive and
Right.
safety and all
Yeah.
that.
Okay, so I'll just say restraint and
Restraint,
transportation.
Yeah.
Okay. And also, policy that was set out in the 2017 budget that I'd have to pull up for you. In the context of contracting with law enforcement or private agencies for the transportation of children, departmental oversight of the secure transport of children, including transport provided by law enforcement officers,
And supervision.
the mechanism used by the department to collect and review data on the application of mechanical restraints during the transport of children in compliance with 5123C, and written policies used to effectuate the law. And then we have the same definition of mechanical restraint, which maybe you just want restraint instead of mechanic, well, let me see.
Right, yes.
Instead of mechanical, you just want the definition of restraint.
it covers all of them, yeah.
So again, just a reminder, we had this discussion about restraint of transportation, and there used to be a requirement for an annual report. We stopped doing it because back at that time, 10 years ago, or whatever, the department said, well, you can ask for it in any time instead of us having to write a report. And then last year we asked for it, and it turned out they didn't have it, and it took them a year to get information back to us. So maybe we need to report again.
Well, I guess that's was, sort of coming back to my question before about if they are signing off on it, then they should be able to have that information readily
It
available.
shouldn't have been that hard. Right?
Yeah,
Right.
and I know from my joint justice oversight and listening to the sheriff's department that they do keep data
Mhm.
on use of restraints, not just for children, for
Mhm.
anybody. But that's not, everyone who provides transportation. There are private transportation providers for this group that we're spending a lot of money on.
Mhm. We just added a
We
million.
just added a million, exactly.
We need to be more directive. Earlier, the references to Commissioner shall ensure supervisory review of every decision to transport. That necessarily, it may imply a written record, but I'm not sure that it requires that.
It should go to number 2, I think, to add that language to make it clear we're asking not just for oversight, but the and that language that you just read.
In both places is what you're saying.
Right, in the reporting part, number 2, departmental
What page are
oversight.
you on?
I'm sorry, on page 17, A2, where it's the report on how they are effectuating the policies, it would be saying, department oversight and supervisory review of decisions to transport, which goes back to page 15C, the
C,
existing
yeah.
statute that we want to, which is cross-referenced through saying the policies of the statute, but it makes sense to be very specific about.
Well, we want to know
What's
the
your
number of
supervision?
percentage that failed to get the supervisory review
Yes, that's right. So,
as an add to that report. Then I don't know how it be phrased, but the degree to which supervisory, and I think it's important what you said, Doug, about making sure that it says written,
yes.
that it should be in that youth's record.
Page 15 line 6.
So that the reasons are documented in writing. Let's see.
Yes.
When transportation with restraints for a particular child is approved, the reasons for the approval shall be documented in writing. Is that sufficient, or do you want additional language?
It's sort of all of C, because it's ensuring supervisory review of each decision. And then
Oh,
the
I
approval,
think, yeah,
right,
it sort of says it in writing already.
yes.
Unless we want to know the number of instances that supervisory review is sought and rejected. But I'm not sure if that's,
I think, Katie, it probably would be good just to say, shall ensure written documentation of each supervisory review in the first sentence as well. Because the second one is just saying, you only write down the reasons for approval.
The second sentence, right? We
Right.
need both sentences.
If you didn't approve it,
Right.
then we wouldn't know that you didn't approve it.
Mhm.
Okay. And then can we go back to the report? So in 2, I have departmental oversight and supervisory review of the secure transport of children. It sounded like maybe you wanted a new subdivision that was the degree to which supervisory review occurs, or no,
Along that line.
occurs, or supervisory review
Of the reasons.
like still results in use of the restraints. Are you looking for something broad, or
For an error rate.
okay?
That's what I'm looking for. So, I mean, the concept of, so the requirement is 100% is reviewed. And do you achieve 100% every time? That's, you know, so, or are there situations where things slip through the cracks and you only are reviewing it after the fact?
It's a percentage of supervisory reviews that occur prior to transport.
Yeah.
I'm just wondering whether we will, in reality, get to that number, because in a sense, it's trying to seek a negative. Will it be brought up? And someone says, oh, sorry, boss, earlier today I transported someone in restraints. I failed to check with you.
Then they're not ensuring that it happens by their training of
Yeah.
staff. So,
I'm trying to envision the instances in which we will discover
oh,
a failure to abide by that supervisory review.
Well, we'll have an opportunity to ask the deputy commissioner about how that would be documented.
Shall I keep moving?
Yes, thank you, Katie.
Okay, page 18, we're changing topics, solitary confinement of children. This was originally drafted by the judiciary team, so you may want to hear from them more specifically on this language. Subsection A, solitary or room confinement shall not be used on any child for discipline, punishment, retaliation, or any other reason other than as a temporary response to behavior of a child who poses a serious and immediate risk of physical harm to the child or another person. A staff member of a facility shall attempt to use less restrictive techniques before placing the child in solitary or room confinement. The technique shall include attempting to de-escalate the situation by talking with the child and permitting a qualified mental health professional to talk with the child. Subsection C, after attempting to use less restrictive techniques as required in B, a staff member of a facility may place a child in a temporary room confinement if the staff member determines that the child's behavior poses a serious and immediate risk of physical harm to the child or another, explains to the child the reasons for the confinement, informs the child that release from room confinement will occur immediately when the child regains self-control, such that the child's behavior no longer poses that serious and immediate risk of harm to themselves or others, or not later than the time period specified in the next section. If a child is placed in temporary room confinement pursuant to C, the child shall be released immediately when the child regains self-control and no longer poses immediate risk of harm to self or others. And if the child does not regain self-control, not more than 3 hours after being placed in room confinement, if the child's behavior poses a serious risk of physical harm to others, or not more than 30 minutes after being placed in room confinement if the child's behavior poses a serious risk of harm to the child.
Yeah, go ahead.
Just seeing a pattern of the word or the phrase least restrictive is popping on up. How are we gonna be able to assess and document that uniformly? I believe we need to provide a definition of what least restrictive is within the definition categories to provide some clarity and really implementation too. Because least restrictive is a very, very broad term. I know there are agency SAMHSA defines it and so forth. So my suggestion is, and I'll lean upon ledge counsel for this, is that we define and clarify that within statute.
Yeah, I think it's a
Definition.
little, I think that what's said here is a little loose with regard to how it's referencing least restrictive. Because it has different meanings in different contexts. And so just for us to be clear, and I'll have to say, I think 3 hours is way too long to leave a child in
Conclusion.
seclusion. Yeah, it keeps calling it solitary confinement, but
It is, yeah.
is there
No,
a
there-
legal reason not to call it seclusion?
That's one of the things I just mentioned to
Yeah.
the chair. When I look side by side, you'll see the next section on restraint and seclusion in residential facilities. There's a lot of overlaps, but where we use different terms. And Representative Rachelson introduced this bill. I'm going to get together with her like in the next 24 hours for us to align language. And one example is room confinement, which appears to be intended and defined the same way we define seclusion under restraint seclusion for residential. So we need to do some work on that.
Okay.
Yeah.
Yeah,
And it's the same thing in terms of the issue of least restrictive. It's used in
Environment, yeah.
both, so.
and it means something very specific in education terms.
Right.
It means something very specific in developmental disability and human
Mhm.
services terms and in mental health terms. And so I think it's a good call for us to be very specific about what it means.
Yeah, it's,
For this.
although it's considered a term of art, the term of art changed in space.
Yeah.
So yeah.
It is termed differently in regards to maybe juvenile detention centers or schools. There is different levels of least restrictive.
Right,
Mhm.
right.
It's vitally important, I believe, we define that.
And so can I ask this whole section, would this be for any, this section is about for any child in DCF custody? Is that right?
I think where this one is placed, it is not. I think I looked at that. Hold on, let me stop sharing and go back. I think this might be in the, let me just look.
Solitary confinement almost seems like that section's talking about DOC.
Well, that's what we just said too.
Yeah, I think this was approached, I think the intent of the representative was addressing juvenile detention or corrections placements as opposed to residential. And that's why we, didn't quite align language, but
Because that's what, section 12 seems to get at what this committee is used to dealing with.
and right, that's exactly right.
Right, solitary confinement is a penitentiary / correctional center.
Which is why that went to judiciary originally and section 12 was this committee.
Yeah, down at the bottom of that section H, it says solitary confinement or room confinement means a form of, I'm sorry if you just read this a moment ago. Physical separation in which the incarcerated child is placed in a locked room or cell for approximately 20 hours. So,
And so this is,
This is in the general chapter. So this would apply to all children under DCF custody.
not just those who are incarcerated.
Well, but then you have the way that definition reads, and the placement of the statute makes me think that it should be broadly applicable. But then incarcerated child, that's pretty specific. I wouldn't,
Also, I guess what I'm gonna, Anne's gonna work with, Representative Rachelson. And I'm just wondering if there's a way to, make this one section, that deals with
I would like to try to do
Restraint and
that.
seclusion.
And that's
Yeah.
exactly what we just
in general. Okay,
exchanged emails about.
okay,
Yeah.
all right, thank you. Okay.
okay. Let's see, I was on E. Staff at the facility is to check on the child at least once every 15 minutes while the child is in room confinement. If the child's behavior continues to pose a serious and immediate risk of harm to self or others, after expiration of the time specified in D2, the child shall be transferred to another facility or location where services other than room confinement can be provided to the child. Nothing in this section shall be construed to limit the use of single-person rooms or cells for the housing of children in detention facilities and does not apply to regular sleeping hours. Further, this section is not intended to apply to such situations where only one child is housed in a detention facility. Conflict with any law providing greater or additional protections to minors. So I think there has to be a policy decision here about who you want this to apply to. Is this a general policy that DCF should have for any child in its custody, or is this specific to children who have some type of criminal justice involvement?
Yeah,
Well,
that's all
I
right.
was just gonna ask quickly, we don't have any detention facilities in the state.
Not anymore, but
Red
actually,
Clover is,
actually, right, and.
Oh, Red Clover is considered a,
well, I think for purposes of this, but there are also youth who are
They're
locked up in
detained in
adult
Correctional
facilities.
facilities. There are youth in correctional facilities. They have to be separated by sight and sound, but they are allowed in correctional facilities. And so I think the policy decision that you're talking about, and I think that Anne can work with, Representative Rachelson, and we can, figure out if we need different wording, if a youth is in a correctional facility.
I think we're,
Versus a youth that's in a residential facility or foster care, frankly.
I think that this is in some ways less restrictive on what the department can do for children in locked facilities with things that we wouldn't permit at all in a residential facility, such as defining it as when the child is placed in a room for 20 hours or more out of 24 hours, whereas with residential facilities, it's defined as at any time you can't leave the room, these different triggers take place. So there are definitely some, and those are policy, decisions. But I think this is accommodating a little bit more the fact that these are children under detention custody rather than in a residential unlocked group home.
If I had to guess, your work with Representative Rachelson will prove ultimately that we need to have two separate. I think we're heading in that direction. Seems like the settings are sufficiently different that setting it out in two different sections.
Right. Or it could
Maybe
be
appropriate.
it could be a subsection of an overall one that says in the case of the child who's in detention. But either way, yes, I agree. We just need some of the language like solitary confinement definitions and so forth to align better. The definition of least restrictive and things
So
like
in
that.
summary, we know these two sections need work. And it's in the capable hands of Representative Donahue.
Okay. So next is the restraint and seclusion. This generally applies to all children in the custody of DCF, that the department shall not use or authorize the use of prone restraints, mechanical restraints, chemical restraints, or strip searches on children. Seclusion and physical restraint shall only be used to prevent the imminent risk of serious bodily harm to a child, staff member, or others, and shall be discontinued at the earliest possible time based on an individualized assessment and reevaluation of the child. Whenever feasible, a child shall be, a child shall be offered an opportunity to cooperate before and during the use of seclusion and physical restraint. Prior to initiating seclusion or physical restraint, other interventions shall be attempted and found unsuccessful, or shall be considered and determined to be ineffective unless the child is attempting to cause serious bodily harm to the child or others, and immediate action is necessary. Only a staff member trained in accordance with rule required pursuant to this section may initiate seclusion and restraint in accordance with this section. The program or staff member using seclusion and physical restraint shall document its use, provide a copy of each recorded use to the commissioner. The documentation shall include a description of the child's specific behaviors justifying the use of the procedures. And D, the department is to collect the following data on the use of seclusion and physical restraint with a T by placement type, program name, and the age, gender, and racial background of the child. The nature of the seclusion and physical restraint used, and the length of time the child was secluded or physically restrained as applicable. Annually, on or before January 15th, the department is to submit a written report to the policy committees containing aggregated data collected pursuant to this section.
Would that be to us or to the Office of Child, Youth and Family Advocate?
No, both, probably. Us and the office.
They're more
Yeah.
likely to look at it, that's all I'm
Yes,
saying.
no, I agree. They absolutely, yeah.
I think we should add the Office of Child, Youth and Family Advocate.
Okay. And then here's our rulemaking that the department is to adopt rules in collaboration with the Office of the Child, Youth and Family Advocate and in consultation with stakeholders prohibiting the use of seclusion and restraint on children in the department's custody for disciplinary reasons. The rule shall only authorize the use of seclusion and restraint on children to prevent the imminent risk of serious bodily harm to the child or others when seclusion or restraint is conducted in the least restrictive means necessary to ensure the safety of the child or others, respects the child's privacy, and avoids physical and psychological trauma. The rule shall specify that the use of seclusion and restraint on a child shall minimally conform with CMS standards for seclusion and restraint in psychiatric care settings, and each use of seclusion and restraint shall be followed by a debriefing for both the child and person administering the seclusion and restraint. The rule shall require that after the use of seclusion or restraint on a child in the department's custody, that notice be given to the department, the Office of the Child, Youth and Family Advocate, the child's parent or guardian, the child's guardian ad litem, and attorney, if applicable, within 48 hours.
So just to note that they have rules existing now. They are not, because of the new parts of law, they would need to redraft them. So this one makes it clear they're somewhat loose. And I'll leave it at that.
And we have some definitions. Chemical restraint is any medication used to manage behavior or restrict freedom of movement that is not a standard treatment or dosage for the individual's condition. Child or children means somebody in DCF's custody or receiving care and services in a program regulated by DCF.
Oh,
Yeah, that's important.
Madam Chair,
yeah.
I go back, a question for you, Rep. Donahue. The current rulemaking, in this, we talk about notice within 48 hours. Is there anything currently on with respect to a timeline for reporting?
I believe that, I can double check. I believe that that's the current requirement. It's not being followed. So the youth and family advocate has indicated that a lot of these are not being received, but I can double check if there's a current, there's an existing time limit. Where is that? Oh, yeah.
You're looking for that. You have cross references to the definitions of mechanical restraint and physical restraint that you've already seen. Phone restraint means a physical intervention technique where an individual is held face down on the individual's stomach. And then we have the same cross-reference to restraint definition that you've already seen. Shall I keep moving?
Yeah.
Okay. Judicial review of placements of children previously under the custody of DCF.
Just before you do, I said that too fast. Too fast. I think it's important for us to really understand what the definition of child and children means, particularly says, or in a program regulated by the department. That is very broad. And that we may want it to be, that means childcare facilities, that means, whatever, I don't even remember all the other ones, but, that's one that popped into my head. So I'm just, putting that little bug in people's ears to be thinking about, if we are intending it to be that broad. I mean, I personally, I don't want kids being restrained and secluded
In childcare facilities, right?
and anywhere. We couldn't get the schools and education to go along with it, but, so I just wanted to sort of highlight that because we've all been talking about kids in custody and that one statement is much broader than kids in custody.
So I'll say in the original concept of this, my intent was any of the like group homes for children that we've been looking at and discussing. I agree, it's a very valuable policy decision to think that we may want to include it to all, but we need to know what those all are, like childcare facilities. So that's something I'm sure we'll hear from the from DCF about that language.
Go ahead.
Going? Okay. So judicial review of aftercare placements. Top of page 24. If DCF proposes an aftercare placement or program for a child exiting the department's custody, the department shall submit a petition containing the proposal to the Family Division of the Superior Court in the county in which the child currently resides. The department is to provide notice of the petition to the child's parent or guardian ad litem, an attorney if applicable. The child's parent or guardian ad litem or attorney. Oh, did I just read that? No. This is their chance to respond. I'm sorry. The child's parent or guardian ad litem or attorney as applicable shall have 14 days from receipt of notice to respond, and the court shall approve the department's proposed aftercare placement or program if it determines that the placement or program is in the best interests of the child. And my understanding is this judicial process is necessary under federal law to receive certain funding. Do I have that correct?
That's exactly right. When Representative McGill and I met with DCF this fall, they identified this as, if you'll recall, in our budget this year, a large amount of money for services for this group of kids was removed because we couldn't get the federal match for it. And she identified this is the key reason, because the federal rules require that there be a court review of some type in order for these kind of programs to be funded. So that's the purpose of this. And we have reached out to Judge Zone about it, and he and the deputy commissioner are going to discuss it, and judiciary will fly by it as well.
What is an aftercare program?
It's after you are not in the department's custody, but I mean, the example we were given is what you remember the example we had on that. They can't.
It just ensures kind of stability and that transition. So you see them often even in like unaccompanied homeless youth programs. And really, it's I mean, boiled down.
Look back at the budget language that explains what.
Well, I guess, Bob, it's a positive thing for the youth.
Yes,
Yeah.
It's supporting them.
It's
I didn't know if it was referring to
transition.
continued. Yeah.
Is
Okay.
BYDC, is that this group that provides the support after they age out or exit custody of the state.
YDP.
YDP, thank you. Wrong letters in the corner.
So I can read
Thank you.
I can read the sentence of their explanation in the budget book. This was meant to provide services to youth for at least 6 months after they exit a residential placement and is one of several requirements that is preventing DCF from drawing down that revenue.
So they would be able to draw down additional federal revenue to support the kids after exiting custody. Sort of as a transition, instead of just like, oh, yep, it's done,
One of the things, and what really piqued Anna and I's interest was, and also is represented on a number of the bills, was it would give them the ability to offer like 6 months of stipends to youth as they're exiting, which is really like a financial, that's one of the biggest barriers, and that's in the UHY part. It's that ability, you need resources. And when you've kind of been separated from your family for whatever reason, you often don't have that. So this just opens up
potential.
That all sounds good. I just didn't know aftercare program, if that was sort of
No.
language for something that really isn't care.
Yeah, no, I think we know most 18-year-olds with their families aren't turned out to the street and saying, go for it, get a job, good luck when they turn 18.
It's not even just monetary, and that's the things we're able to just to address. But think about, when you were late teens, early 20s, if something happened, you'd call your mom and dad to help you navigate it. And they don't have that. And so I think a big part of a lot of these sections of the bill is how we as a state can provide that, or some semblance of that. We're never going to be able to repair that kind of fracture, but I think we can do a lot better than we have been doing.
And we can get federal money to.
And we can, yes.
Okay, section 4, also related to the aftercare placements. By September 1st of this year, DCF is to submit a written report in consultation with the judicial branch to the policy committees containing a proposal to implement an aftercare placement or program for children exiting the department's custody in a manner that meets federal requirements to draw down federal funds and that ensures sustainable use of judicial resources. The report shall include any recommendations for legislative action. And this last section is a section that Michelle worked on, the Pregnancy Surveillance Working Group. First, in section A, it creates the working group to examine DCF's current practice of using a pregnancy calendar to monitor and track certain pregnant individuals in Vermont and provide recommendations on alternatives to a pregnancy calendar and ways to support pregnant individuals in need of services. The membership includes the Deputy Commissioner of the Family Services Division, the Vermont Child, Youth and Family Advocate or designee, the Executive Director of the Vermont Family Network or designee, Executive Director of Legal Aid or designee, President of Planned Parenthood of Northern New England or designee, an individual with lived experience appointed by the Speaker, an individual with lived experience appointed by the Senate Committee and committees.
And this, I just want to point out, we just needed to get something on paper. And so there are other groups. Not all of these have been consulted with. It was really just a starting point to get into that.
We decided on the pregnancy surveillance.
It was
It's
supposed,
theirs.
yeah.
Oh,
That's what DCF called.
no, I'm not saying it was a fun or anything. It just never just sounds so.
Yeah, $50,000 is too much money.
Surveilling your pregnancy.
Sorry.
I think they just took the amount that was in the, what was allotted in the education.
Yeah. Okay.
We figured it
When
would
we-
get cut
yeah,
down.
when we get to mark-
You start high and then
We get to mark up for it.
haggle down.
Yeah.
That what, I got stuck at certain pregnant individuals. Is that?
Because they're not,
They don't monitor all pregnant individuals.
Yes,
And
right.
they're
So
not-
just mean-
yeah, we don't know who or how or why they choose the
What's
ones.
the selection criteria?
Yeah.
Is this?
This hit the news last year.
Right, and that highlighted a serious problem from my perspective. Is there a positive use of a pregnancy surveillance calendar? And this seems to almost sanction it in a way and try to find a more useful.
There
Is there a,
are some nuances within, and now I'm forgetting the federal term, and we also didn't want to, we thought about making our own recommendations, but there is a lawsuit kind of playing out, and we didn't want to then potentially get in a spot where we have different the legislature says something different than a judge says. So we created the working group. And yeah, that's one of the things. And we kept the charge. We just knew this was going to get chopped and
Kept it broad enough so that.
yeah, and figured our committee can kind of do the work.
The working
Here.
group, right.
Yeah.
So just to give an example that,
Highly amendable.
yeah.
Careful with that term.
The example that
I caught the
DCF
look.
used at the time that this was uncovered, was like, well, this is highly limited, and they address a lot more. But if a pregnant person has had all of their previous children removed for abuse by DCF, and they're addicted to drugs, that they want to monitor when the baby's going to be born so that they can intervene right away. That was one example. And there may be some valid uses of that, but not to expand it to anyone who's had DCF involvement or something like that. So that's what really needs. to
Even
be-
when they were a child.
Yeah, right, that's right. So there may be, there may
Accusations
be
by
some,
unspecified
Specified
people.
yeah, there may be some reasons for some monitoring of a pregnant individual, but they would seem to be extremely narrow if so, and that's.
Just going back to the membership, the network was one that we meant to add and was in our back and forth, and we
Oh.
realized after it was not on there. So
So Network Against Domestic and Sexual Violence.
but then we have an even, so yeah, we'll have to do some.
So, and I didn't know with lived experience, if that meant the lived experience of being pregnant or lived experience of being pregnant and having been monitored.
Yeah. We meant with monitored, but
Someone.
yeah.
Someone who has experienced previous
Yes.
monitoring.
Mhm. And we
So
had.
I think we should actually be specific
Yeah.
about that, Katie. Okay.
Shall I keep going?
Yeah.
What's
at the end?
Just ask a question regarding the membership, and I'm not going to remember the name in the moment, but the organization that Larry Quist serves as the executive director.
Yep.
They have probably been tied in with this population impacted by the schedule. I don't know if that's someone for an organization for consideration.
Yep. And I'm trying to remember the
I
name
know,
of the
I'm
organization.
going through the-
Certainly find it. And to the chair's question or reference to the $50,000, that seems like it's tied into perhaps the hiring of someone to assist this group.
Yeah, I'm not sure we need somebody to assist
Yeah,
her.
I was gonna.
That was your idea.
I know.
An independent facility, yes.
Parent Representation Center.
Yes.
Add that?
Yeah. Yeah, because I did, I never recall saying that, thank you. I'm just thinking now that when I see a dollar, it's that that's, if we want that to fly, that's not likely to fly.
Yeah.
So.
Subsection C is the duties of this group. It's responsible to study the current practice of using the pregnancy calendar and to provide recommendations on alternatives to a pregnancy calendar and ways to support pregnant individuals in need of services. Assistance, DCF is to contract with one or more independent consultants or facilitators to provide technical and legal assistance for the working group and for the work required under this section for the purpose of scheduling meetings and providing admin assistance. So work groups will have the assistance of DCF. By November 15th of this year, the group is to submit a written report to the policy committees and in judiciary, it's policy committee, but that's finding and any recommendations for legislative fiction. Meetings, my computer is about to die. Let's see how long I have here. The Vermont Child, Youth and Family Advocate or designee shall call the first meeting of the working group to occur on or before August 1st of this year. The group shall select a chair from among its members at its first meeting. The majority constitutes a quorum and the group ceases to exist February 1st of next year. Members of the group who are not otherwise compensated for attendance at meetings shall be entitled to a per diem compensation and expenses as permitted in statute. Wow. That was amazing.
Lori is always listening.
Oh my goodness, thank you, Lori.
It was suspenseful. I wanted to kind of see if she was gonna make it or not.
It started dimming, so. Okay, and then we have our, not more than 5 meetings for that, compensation and reimbursement. And then 50,000 is appropriated, to DCF from the general fund, for fiscal year 27 for the purposes of the per diem and reimbursement of expenses and to hire 1 or more facilitation consultants pursuant to this subsection. You have, an effective date of July 1 of this year, and then this is renamed to be an act relating to miscellaneous programming and requirements within DCF, which I'm not crazy about, so I'm open to other suggestions. We'll see where this lands and maybe come up with a better title.
Yeah,
Yeah.
I would probably substitute various as opposed to miscellaneous. Miscellaneous
How about
Sounds
certain?
pretty, yeah.
or certain. Miscellaneous makes it sound minor and it's not really minor.
Right.
Just have one, question. Obviously, the scope of this bill is, the expansion has gone far beyond its original intent. And,
On purpose.
Well,
yeah, I know,
combining other bills into one.
yeah,
Yeah.
but, I do have a concern with the amount of, are there any sections within this bill right now that likely are gonna be required significant delay for implementation? Does some timelines need to change due to
Yeah, I was wondering. about that.
rulemaking and as well as others? I mean, we're talking about some major system changes here and as well as rulemaking, and it's July 1st.
Yeah, there are different sections that will need different effective dates. Yeah, I agree. I don't know exactly what they are right this moment. As we go through markup and as we take witness testimony, I'm sure that we'll get feedback from the department, from the judiciary, from Child, Youth and Family Advocate. So right now, we're talking about having Judge Zone, Deputy Commissioner Radke, Child, Youth and Family Advocate, Voices for Vermont Children, the Public Defender's Office, and the Treasurer's Office. Because they will have some involvement in the SSI financial section. So that's sort of the witness lineup for right now.
I would also have Favor Ellis from Elevate Youth Services. She's the executive director there.
Okay,
And they are the statewide administrator for all of our runaway and homeless youth funding
Okay.
that comes in. And they're the statewide administrator for the YDP.
I was just gonna ask if that was the way. All right. Yeah.
Just the question about that 48-hour reporting.
Mhm.
I just got a note from an outside party pointing out that the current rules actually say 24 hours. So I think we'll want to say 24 hours. More time, but they already have that in
In their rules.
in their otherwise fully adequate maybe rules, but they do have 24 hours.
Okay.
So, Katie, if you got that, where we 48 hours for reporting to the department, et cetera, if there's restraints being used, that should be 24.
Okay. So, there's obviously a lot of work to do on this bill. And page 23.
I got it.
Oh, you found it?
Yeah, thank you.
All right. And we're gonna, try to, put in some of these witnesses. Like Deputy Commissioner Radke knew about the bill coming, so, you know, I'm sure that she is, been preparing and all of that kind of stuff. So, hopefully we can get her this week. I would like to have at least, three of the witnesses this week in our, areas that we have some TBD. So that, we can tell what kind of significant markup that we'll need when we return from break, because that is we have 1 week after we get back from break, for crossover, so. Right, and, okay, so that's that on that bill. Thank you so much, Katie, and I sincerely apologize for making that shift on you, but I felt like people needed to sort of start to get their head around all of the various concepts that are laid out here and have time to think about them before we have the witnesses pop in. So, but we are going to do what is on the agenda for the afternoon. Okay, so, we're going to take a little break before our 11 o'clock, which is picking up on some of the background from our meeting yesterday, pre-K. We have lots of subjects that we do in this committee. It's never boring. So we're going to have Beth St. James in here to talk about what is the current statute. So everybody, you know, we keep talking about UPK and all of that kind of stuff, but what does the statute actually say for that? And I think we're going to look at kindergarten as well. So it's amazing what the statutes say and then also what they leave out. So we're going to do that.